tradition and morality in Korean jurisprudence. And there's a lot of different areas of law that I could look at to make this point. But today I thought I would focus on a set of Korean constitutional court cases dealing with family law and criminal law issues, part because I think they most starkly illustrate the points that I want to make. So law, tradition, and morality. I mean, so I think the easiest way for me to start would be just to dive right into it, that the Korean Constitutional Court, some of you may be familiar, is a post-democratization. So unlike Professor An, I have never given a talk without the words democratization, neoliberal, post-IMF consensus, democratic consolidation. I mean, this it would be strange if I didn't actually say that early on. But it's it's considered one of the pillars of post-87 democratic consolidation. There are it's got a rich body of case law at this point, even though it's only been 20-something years. Throughout its history, it's had to deal with a number of issues at the intersection of tradition, morality, history, and maybe even sociology and the law. So, as many people know, the Korean Constitutional Court has considered the constitutionality of the criminalization of adultery 3 times since 1988. Each time it said it's constitutional. Korea is one of the few countries, non-Muslim countries in the world that criminalizes adultery and actively prosecutes it. Adultery is criminal in many U.S. states, a little over 20 in my last count, but then nobody prosecutes except in the military. In Korea, there's about 2,000 prosecutions a year, right, which is a very high number in a non-Muslim state, right, perhaps the highest. And again, they say, well, look, it's a proper state legislative purpose to try and regulate marital behavior. And I love this one. So they make the claim that, well, they do a pseudo-historical review, and they say, well, the idea of chastity is inherent in Korean society. And so then they decide, well, given the inherentness of this idea and how morally important it is and how empirically it's been sustained over time, legislative action is, of course, appropriate. The first is, of course, by deciding on the legal limits, the court is debating and defining the boundaries of transgression, because at least at a very simplistic level, what is illegal, certainly what is clearly a facial violation of the criminal laws, is at that basic level seen as being transgressive, right? Sometimes the court defines the transgression in a more supposedly traditional, more morality-based manner, and other times it goes with what may be the neoliberal Washington consensus type of regulation.